so much for tuning in this evening again. We're going to talk about estate planning, which is something I am passionate about. Back in the day, people used to say to me, "Oh, you're talking about estate planning? That must be a pretty like morbid topic because you're talking about death." And at this point, I've kind of gotten over that because we all know that part of life that we're not going to be here forever. So we can just get that out the way. Estate planning is not really about death. It is about planning for the future of your family. It's about leaving a legacy and you being in control of what happens to your assets after you leave this earth. But it also helps you to talk about things like put plans in place for what happens if I become incapacitated? I'm unable to care for myself. I'm unable to make medical decisions for myself. I'm unable to make financial decisions for myself. How do I make sure that the right person is in place to take care of those things for me? That is another part of estate planning that a lot of people don't really think about. So, tonight, as we talk about estate planning, we're talking about reimagining estate planning. We're talking about looking at estate planning from a different perspective. And when we do that, when we get out of the doom and gloom of, oh, I'm talking about, how I'm going to split my property up after I die, and we look at it from a positive, empowering, exciting opportunity to leave this world a little bit better than it was when we first came. That's how I like to encourage people to look at estate planning. I also like to encourage people to look at estate planning as an opportunity for you to look at your past and look at your present and see, is this the direction that I want to continue going in? Am I in a place where I'm setting things up the way that I want to? Do I need to make some changes? Estate planning is a really amazing opportunity to take a deep dive into your finances, into um, just what legal things are going on in your life. And then if something needs to be changed, it's a great opportunity to do that. So when I work with clients on estate planning, we're looking at everything that you own. I'm going to ask you to create an inventory. I want you to tell me how much money you have in what bank accounts. I want you to tell me what property you have, where it's located, who your family is, who you like, who you don't like, who you want to include, who you don't want to include. If you want to look at things from a community perspective, what impact do you want to make on your community with your estate planning? All of those things are going to go into the conversation when we're doing your estate planning. And then a lot of times people, when they talk to me and they give me all the information and I review it to them with them, they say, I didn't even realize I had that in place. I hadn't updated my life insurance beneficiary designation since my husband passed, and I didn't realize that. And so now, since my beneficiary is deceased, I need to update that so that somebody can receive the proceeds of this life insurance policy without having to go through probate. Those are the kind of things that we get to dig into and get to put plans in place for when we do estate planning. Now, y'all don't let me get this far talking to y'all about estate planning, what it is, what it ain't, and what we get to do with it. And I didn't even tell y'all who I am. So I am attorney Veronica McClendon. I am the owner and CEO of McClendon Law and Consulting. My law firm is located in Macon, Georgia, and I serve the entire state of Georgia when it comes to estate planning. If you're on here and you do not have property in Georgia or you do not live in Georgia, I think that a lot of the information that I'm going to cover is going to be broad enough so that it's still helpful to you. You're going to learn some things. You might get to ask questions about terminology that you were confused about. But in terms of being able to help you with your estate planning, I personally would not be able to do that. However, during the years that I've been doing this work, I have developed quite the network of other attorneys across the country who might be able to help you. And they think in a similar way as me in terms of wanting to help families to preserve their wealth and create a legacy that outlives them. I have a network of people who work in issues concerning heirs property, estate planning, probate. So the people that I refer you to are folks that I believe you'll be in good hands with them. So don't despair if you came on here looking for help in your state and I'm not licensed there. I encourage you to still come on here, engage, ask questions, share your insights, and I'm hoping that this is going to be an amazing opportunity for us all. I love doing things live because it gives me a chance to hear from you and to learn from you as I go because I don't know everything and I improve when I get to hear from others about their challenges, their questions, their concerns. It helps me to get better at being a lawyer when I hear what other people have gone through. It helps me to figure out how can I make the experience more positive, more exciting, more impactful for the people I serve. So I'm here for a give and take for us to learn from each other and to share with each other. And I hope that you can let me know what's important to you. So if you are here on Zoom, I'm going to ask if you would just put things in the chat. If you have a question that you want me to address about estate planning, if there's an issue that you've experienced with estate planning that you would like for me to talk through, put that in the chat on Zoom, and I'll do my best to address those as we go throughout this conversation. I do encourage you not to put anything that's overly personal. I don't want your confidential information being shared here on Zoom or on YouTube. So keep it kind of, indirect. Don't put too many details and make sure that you protect your own information because I can't do that for you here on this Zoom. I do my best to the extent I can. But feel free to put in the chat what brought you here. Why are you here? What questions do you have? What are you hoping to learn? I love to hear from you and be able to talk through some of those things as I go throughout this presentation. I also want to let you know that this time here is for me to share information with you, but it's also to give you an opportunity to work with me. If you are a resident of Georgia or you have property in Georgia and you're looking to do some planning in the state of Georgia, I want to talk with you about the way that we can work together to get your estate planning done. Because I don't want you to just come here and get a lot of good information and then you leave here and you're in the same position. I want you to think, what can I do to set my family up for the future so that they're better off with, after I'm gone than they would be if I did not have a plan. That's what I want you to come away with. How can we get you toward that next step? So, with all that being said, I'm gonna put some information up here. We'll put my PowerPoint up so that we can get this conversation started. Every time I do this, I realize that I got to do some some deep dive into the tech aspect of things so that I can make my transition to the slides more smooth, but I haven't gotten there yet. So we're just going to work with this. Y'all bear with me as I get my slides up here. Like I said, feel free to put any questions or comments that you have in the chat. And we are going to get this presentation going. I'm going to share this. And as I share it, I'm going to start my slideshow from the beginning. So I like to call this Estate Planning Reimagined. Like I mentioned when we first got started, I want y'all to see estate planning differently than perhaps you may have seen it before. About my firm, I told you a little bit. So I am the owner and CEO of McClendon Law and Consulting. Our firm provides heirs property, estate planning, and probate legal services to help farmers, landowners, and other legacy-driven individuals build wealth, increase their income, and secure their legacies. So you may not be someone who is a farmer or a landowner. You are still in the right place. If you have a mind that estate planning is more than a piece of paper, I'm actually trying to create a legacy and leave a legacy for my family, then you are in the right spot. So we're going to talk about estate planning, as you know. And before we talk about an estate plan, we got to get clear on what is an estate. I will tell you, this is something that a lot of people get confused on. They'll think, well, I don't really have a lot of money. I don't have a lot of land, so I probably don't have an estate. And I like people to know everybody who is a person is going to have an estate of some sort. It could be two pennies or it could be $2 million. If you own any money and property at the time of your death, then that ownership, whatever you own, is going to be part of your estate. And it also can include things like legal claims. A lot of times I have clients who come to me because their loved one has died in an accident or something of that nature, and there's going to be a legal claim associated with their death. Or perhaps that their loved one was entitled to some money. Maybe there was some kind of a lawsuit that was filed on their behalf, and they didn't get to see the end of that lawsuit, and now someone needs to be appointed over the estate in order to handle that claim or receive the money from that claim. All of those situations could come up. So that means that all of us have the very strong potential of having an estate at the time of our death. Your estate plan is your written instructions for how your money, your property is going to be distributed after you die, caring and providing for minor children or other individuals or matters if you're over like a business or you're over land or whatever responsibilities you may have. Sometimes you need an estate plan to address what happens to those situations after you die. Making healthcare and financial decisions for a person while they're still alive, but if they become unable to handle their own affairs, they might have a mental incapacity or even a physical incapacity that limits their ability to be able to make decisions on their own behalf or take certain legal or medical actions or financial actions on their own behalf. So when we're doing estate planning, we're covering all of those bases. So what you're doing is creating a plan to pass on your personal assets. What happens if you become incapacitated, providing for your loved ones who depend on you, and planning for long-term care. We got to think about that. People are living longer these days, but they're not necessarily in a place at the end of their lives where they're able to care for themselves. So we have to make sure that we have a plan for how am I going to pay for long-term care expenses, such as a nursing home or having an in-home aide to come and care for me if I become unable to do that myself? How can I set things up so that I don't bankrupt myself and bankrupt my family in the end of my life when I need additional care? And if you are a landowner or a business owner, your plan is going to need a bit more. You're going to have a plan that passes on your business assets and also your business operation, the know-how. You don't want to have a business and then something happen to you and that business have to stop because there was no plan in place. So if you have a business or if you own land or a farm, you also need to have a succession plan in place for that business, that land, or that farm to make sure that it doesn't just stop with you. And I wanted to say something really quickly. You might say, well, I have my business and I really only have it for me. When I'm gone, I really don't care what happens to it. And that's fine. But if you can set things up so that your business is in a position to be sold, or if it's wound up in a way that your family gets to benefit from it, I would love for you to set that up that way. Because you might have something, it may not be worth multiple millions of dollars, but maybe it's worth $200,000. Maybe it's worth $50,000. Whatever it's worth, I'm sure your family's going to appreciate receiving that. So if you set things up so that there's a plan for what happens to that business, that land after you die, your family or whoever you leave your estate to can inherit an asset that becomes something valuable to them. So we're talking about estate planning components. Now, what goes into an estate plan? Typically, it's going to have a will. You may have a trust. If you have a business entity like a LLC or LLP or any other kind of business entity corporation, you need to have some business succession documents in there, maybe some buy-sell agreements. If advance director for healthcare, financial power of attorney, life insurance and other benefits, you want to make sure those are lined up. I'm actually working on an estate now where someone had a life insurance policy. They named a family member as the beneficiary. That beneficiary died before they did. And now their other estate, the only heir to their estate is trying to get those life insurance proceeds. And the life insurance company said, well, since the named beneficiary is deceased, we just have to send this money to this person's estate because we treat it as if they had no beneficiary. So we want to look at your life insurance policies, your retirement policies. Make sure that your beneficiary designations are up to date and that what you have is going to the people you want it to go to. Also, estate planning can include making funeral arrangements. If you've ever had to plan a funeral for a loved one, you know that it's not only expensive, but it's a lot of details to put together. And if someone has already put the thought in the planning into that, that's one less thing that the family has to think about. So let's talk about a will. I've been so intrigued to learn how many questions and concerns and misconceptions there are about wills and how they operate, what their purpose is, how do you administer a will at the end of a person's life. So we are going to talk about that now to make sure that y'all know what's going on if nobody else does. You can share it, tell somebody about it too. Speaking of telling somebody about this, if you know anybody who could benefit from this information, I encourage you to send them the link to this video. If you are watching on Zoom, then you can send them the same link that you use to register. They can register, join in. Or if you're watching on YouTube, then you can just send a link to this video to them so that they can tune in as well, especially if you're a child of a parent who has been dragging their feet about estate planning. You might want to share this with them and see if it might encourage them to go ahead and get it done so that you are not having to administer their estate after they're gone and deal with a whole lot of issues and mess. So just a little plug, say share this with someone that you love or someone that whose estate you don't want to have to deal with because they didn't plan. Um, Back to the info. What does a will allow you to do? Your will allows you to create a plan to distribute your assets. You can nominate an executor. You can fund a trust, nominate a guardian or trustee for your minor children. And also, if you are a person who likes to give to charitable causes, you get to do that in your will as well. When you're executing a will, these are the requirements. A lot of times people say, well, can I just write down what I want to happen and then get it notarized? Could that be a valid will? The answer to that is no. To execute a valid will, you must be over the age of 14, which is most people are surprised you can make a will if you're 15. You must be of sound mind. You must not be dealing with any undue pressure or undue influence from someone who is trying to make you get a will done or make you do it this particular way. Your will must be signed in the presence of two witnesses, and those two witnesses should not be anybody who is going to receive under that will. We have had people who signed as a witness on their parents' will, and everybody got something except for the person who was a witness. Because if you are a witness to someone's will, you forfeit whatever you get under that will. Also, the two witnesses must sign in each other's presence, and you can have a self-proven affidavit. This is where the notary part comes in. So you can have a valid will without having a notary involved. But having a self-proven affidavit will make things a lot easier for your loved ones, because what happens is when you have a will and you have the two witnesses, when the person dies, in order to prove that the will was done in a proper way, the court's going to want to bring those two witnesses in to say, yes, this will was executed under the right requirements. If you want to avoid having to drag people into court after you have died to prove that your will was done properly, you need a self-proven affidavit. So instead of having to prove it in court, this self-proven affidavit is something that's completed at the same time that you sign your will. And it's basically everybody who was present saying, hey, we saw that this will was done validly, and all the things that's on this slide right here were done properly. And we're certifying that this stuff happened the way it was supposed to. We're signing our names and we're getting it notarized to show that the people signing actually are who they say they are. Whenever I have a will signing, when I have a will signing, my notary is always going to want an ID, because they have to be able to verify that these people who are signing this document are who they say that they are. And that's why the court doesn't later have to come in force those folks to come into court and prove that the will was done properly. So I'm gonna say a few more things because I took off some of my other slides for the sake of time. One thing I want to say is that your will should, here in the state of Georgia, again, I am a Georgia licensed attorney. So the things I'm talking about right now are Georgia rules. There are some states that require 3 witnesses. There are some states that do require a notary. There are some states that require something else that I don't know because I never read those state laws. So this is Georgia law. If you live in another state, you need to find out what are the requirements of executing a will in your state. Or better yet, for all of you here, get a lawyer licensed in your state who has experience with estate planning to do your will. I do not encourage anybody to do their own will. I know it looks easy. There's a lot of stuff online that makes it seem like everybody can do it. I'm not telling you that they're bad or anything like that, but what I am telling you is that there are certain things that must be in your will, or certain things that if they are in your will, it's going to make your family's life a lot easier, or the people you leave behind to administer your will, it's going to make their life a lot easier if you have those things in the will. And we're not in law school. We're not in estate planning 101, how to write your own estate planning class. So I cannot tell you all of the things that you need to have in your will. You need to talk to a lawyer who is dealing with this every day and who's had to probate a few wills that didn't have those things in it to write your will. Like for me, there are certain things that I do for wills that I didn't do 5 years ago because I didn't even know that they were an issue. But then I had to administer wills or probate wills that didn't have those requirements. And I'm like, okay, so now every time I do a will in the future, I'm going to do XYZ, or I'm not going to do XYZ. These are things that I can't tell you here on this webinar, but I can tell you that if your lawyer has done this a little bit, and if they have been in probate court, probating wills a little bit, they will help you to get a much better will than you would come up with on your own. So that's my little tidbit. There are a few other things I would say here. Here in Georgia, you want to have a statement that waives the requirement of filing an inventory with the court. You also want to have specific requirements that say that you are waiving your executor's requirement of filing annual reports to the court. There might be some other things, the need to waive a bond. In fact, I actually did a YouTube video about this that I'm going to put in the description of this video once I'm done. I did a YouTube video on it to talk about what your will should include if you're in Georgia to make things easier for your executor. Some people do want the court to supervise the executor for one reason or another. So in that case, you might not want to put those things in your will. Again, this is where having an experienced estate planning attorney comes into play, because we can tell you, hey, you got these things going on in your family. We want to make sure we put these provisions in your will, or that we leave these provisions out, because we don't want your family to have issues over this. So this is what's required in a will. When you have a will, you're going to name an executor, and that executor is going to be in control over your estate. Their job is to execute your estate and make sure that your wishes that you put in your will are carried out. It's not a lifetime appointment. Once they become your executor, their job is to get in there as quickly as possible, get your estate assets transferred to the people you've named in there, pay any debts, and get out of there. That's a misconception a lot of people have. Another misconception a lot of people have is that if I have a will, my family does not have to go through probate court. And that is completely wrong. A will is designed to go through probate court. So if you want to have your family avoid probate court, you might want to look into a trust. And so we're going to talk about trust for these next few minutes. And y'all get to talking. Okay, I got 30 minutes. I can do this. And I still have some time for Q&A at the end. A trust is a legal arrangement in which one person takes responsibility for the property or the money, for property or money of another person, and manages it for the benefit of one or more parties. So don't write that exactly. I left out a couple words. A trust is a legal arrangement in which one person takes responsibility for the property or the money of another person and manages it for the benefit of one or more other parties. There are different types, and I'm going to show y'all a little diagram that I hope will make it a little more clear. Many types of trusts. They could be revocable or irrevocable. Revocable means that you can change it during your lifetime or you can completely get rid of it. Irrevocable means that you're not supposed to change it during your lifetime and you're not supposed to terminate it. You might have to put a provision in your irrevocable trust that allows somebody else to terminate it if that becomes necessary, or allow someone else to change it if that becomes necessary. But when you have an irrevocable trust, you are not supposed to be in charge of that trust. Because what's the point of having an irrevocable? Okay, let me step back a little bit. I'm jumping the gun. Yeah, I'm jumping the gun. A revocable trust, you can be in charge of your own trust. And that's why you get to change it and cut it out and say, I don't want to do it anymore if you want to. With an irrevocable trust, you don't have control. You give that control to someone else to serve as the trustee, and they have the responsibility of handling your trust and making sure everything goes the way that you've said. And the reason why we do that is because an irrevocable trust is designed to create a certain level of protection of the assets. Also, it's designed to create separation from you as the original person that owned the property. So I'm gonna go a little bit in the weeds and I'm gonna come out as quick as I can. An irrevocable trust, let's say that you create it because you want to be able to become eligible to receive Medicaid, to pay for long-term nursing home care, if you become incapacitated. What you're doing is saying, I am the owner of this property. I don't want it to be counted when it comes to determining if I'm eligible for Medicaid. So what I'm gonna do is at least 5 years before I think I would need nursing home care, and in other states, that time period might be different. I'm going to take the property I own and put it in this trust, and I'm going to put somebody else responsible over this trust. So if somebody comes to me and says, Veronica, um, you need to, if you want to go into a nursing home, you're going to have to pay for it yourself because you have too many assets and you don't qualify. I can say, no, I don't own anything. I put everything in a trust several years ago and I don't have any control over it. So even if you want me to pay for it, I can't because I don't have access to that money. Somebody else is over it. So that's where you have an irrevocable trust. I told y'all way too much for this little webinar. We're gonna have to have another webinar on irrevocable trust because it's too much that I need to cover to really get y'all to understand it. But I hope that that was like a good overview to help you understand the difference between a revocable and irrevocable trust. You also can have special needs trust if you have a beneficiary that has a disability and they receive public benefits. You can leave anything you want to leave to them in a special needs trust or a supplemental needs trust. Those words are interchangeable. That way they can have some property available to them that can be used for certain expenses and it won't disqualify them for public benefits such as Medicaid or public housing or food stamps or whatever, I guess we call them SNAP, whatever they might need to help them to take care of their daily needs, housing, things like that. You also can create charitable trusts. You can create a trust while you're living, which is inter vivos, or you can set up a trust in your will or in your trust. You can set up a sub trust that only becomes effective after you die. So those are a few different types of trusts. There are so many different types of trusts. And I say it like that because people say, I saw on the internet that I should get a trust. And I'm like, okay, we need to talk about what your goals are and how your life is set up because a trust may be the right thing for you, but we got to figure out what kind of trust. Why do you want to trust? What are you trying to accomplish? We got to get into all that to see what kind of trust is going to be best for you. So this is how a trust works. You have trust property. It might be a house, money, car, not really cars. It could be classic cars. Um, Anything you own, business, um, retirement funds, investment accounts, whatever it might be. You have that property. It's in your name at first. You're the settlor, or I like to say grantor. I don't know why I haven't changed this, but I like to say grantor. They have property. They transfer that property into a trust. There's a legal process you have to follow to transfer it into the trust. You have a trustee who is responsible for managing that trust, and then they manage it on behalf of the beneficiaries. If you have a revocable trust, you could be the person who originally owned the property, you could be the trustee and the beneficiary during your lifetime. But then you set it up so that if you became incapacitated or after you die, somebody else would be your successor trustee. And you would no longer be the beneficiary, of course, but you would have other people who would be your beneficiaries who would receive the property after you've died. So, what happens if you die without an estate plan? We're trying to prevent that with this conversation, but it won't prevent it if you don't take action. You're going to have to take the steps to hopefully hire an estate planning lawyer to create an estate plan for you so that you don't have to your family won't deal with any of these scenarios. Because if you die without an estate plan, your possessions will be distributed to your heirs at law, and that's going to be based on state law. Here in Georgia, your heirs at law are your surviving spouse and children if you have them. If you're not married at the time of your death, it's going to be your children. If you don't have children, but that you used to have children, they have died, then it'll be your grandchildren. If you don't have children or grandchildren, we're going to go up to your parents. If your parents are deceased, we're going to your siblings. Then we go into your nieces and nephews, and then your great nieces and nephews, and then we come back up to your cousins, and it's a whole process that's used to determine who your heirs are. Some states say half of your property goes to your surviving spouse, the other half of the property goes to your children. But if you don't have children, the other half of your property goes to your parents. Your spouse get half, your parents get half because they want to have half of your estate go to the family you chose and then the other half go to the family that you were born into. That's all going to depend on your state. If you don't want the state deciding who's going to get your property, you need to make sure you have an estate plan so that that's you get to be in the driver's seat. So if you want to be in the driver's seat, if you don't want the state to determine where your property goes, if you have minor children, who's going to take custody of your minor children, if you don't want this judge to appoint who's going to administer your estate, or if you don't want your family fighting over who's going to administer your estate, that's a big issue. You might have two sisters, and how do you decide which sister is going to be over the estate? The court is going to listen to see which sister comes in and looks the most professional and the best dressed and talks the best story. They're going to decide which of those two sisters should be over your estate. And then if they can't decide, they might put a court appointed administrator over your estate, which is going to be a lawyer who you may not even know, who's going to be responsible for administering your estate. And some judges are real quick. They be like, "Oh, y'all can't agree, so we're just going to go ahead and appoint a court appointed attorney to handle this." And usually everything's going to get sold. The court appointed lawyer is going to get their fee, which is going to be heavy depending on how hard y'all fight. And then they're going to split whatever's left between the heirs. Um, and not only that, before it gets to the heirs, they're going to pay your expenses. And it's all your family, if they get anything, it's not going to be a whole lot. So if you're wanting to avoid that kind of scenario, that's when you got to create your estate plan. And that's why we're here. Because I want to help make it easy for y'all. I want to show y'all somebody who cares about you and who's going to help you put your wishes in place. When you have your estate plan, you decide in advance how things are going to go. That takes a burden off of your family and helps you to maximize the value of the assets that you pass on. You can create a legacy that outlives you. You want your legacy to be positive. When my mama died, or when my daddy died, or when my grandma died, everything was so smooth. The executor of the estate knew exactly what to do. They distributed everything to everybody in a timely manner. We didn't have any fights because everybody knew what they were supposed to get. That's what you want. That's what you want. You want your grandchildren saying, you know, when my granddaddy died, I was able to use that money to start a business. I was able to use that money to buy my first house. I was able to go to college on that money. I was able to pay my rent for the next year and not have to worry about that while I was going through school. It may not be a lot, but you can pay somebody's rent with $10,000, depending on where they live. Let's say 12, 15,000. You can pay somebody's rent, or you can pay a good bit of it. It don't have to be a lot to make a huge impact. But if you don't have a plan in place, you're not gonna be able to make that kind of an impact. And so I want y'all to be able to leave the legacy you desire to leave. And that's why I'm really pushing this estate planning, because I know that's the way to get it done. So I talked a lot about what is an estate plan and why you need to get one. This is the how to create an estate plan, which I'm gonna kind of skim through because y'all don't really need to know how. Y'all just need to know that y'all need to do it. I hope I got y'all convinced on that. But when we're talking about how, then it's also not just to get a piece of paper, write down what you want, type it out, and put a heading on there. Like, it's not just how to craft a document that can be used in your estate plan. It's like, what do I have in my mind when I'm approaching estate planning? How do I look at it so it's not just this drudgery that I have to do before I die, but it's something I actually enjoy doing because I know it's going to have an amazing impact on the people I love. So the first thing you want to do, well, let me say this. I like to approach it as a gift. Establish your goals, create an inventory, select your fiduciaries, and assemble your team of advisors. When you have your goals in mind, you're beginning with the end in mind. You're thinking, what impact do I want to have on those I leave behind? What do I want them to receive? Do I want to be able to pay my grandchild's rent for a whole year if they need it? Do I want to be able to help my little great grandbaby who I know I probably won't see to adulthood, but I want them to be able to start a business if they want to. I want them to be able to go to college for their first year without having to pay anything out of pocket. Cast that vision so that your beneficiaries, the people you leave as your trustees, your agents, your executors, they can pick up the torch where you leave off and keep running. They don't have to like trip and fall and then build everything back up because you already gave them a foundation to start with. Creating an inventory. You want to make a list of everything you own. Like I said, this is an eye-opening process. When you were like thinking, okay, what do I own? Oh, I forgot that I got that little acre of land down there in I don't know, Baker County, just throwing out some counties. I forgot that I had that bank account. I mean, it's not a whole lot of money, but it's something. I forgot that I had that bank account. Wow, I did not realize that my net worth is actually over $1 million. I never noticed that until I actually made this inventory. You want to look at real property, cash and bank accounts, investment accounts, farm equipment. If you're a farmer, I got a lot of farmers as clients. So I got to include farm equipment. Don't forget those tractors, vehicles, valuable personal property, business interests, all of it counts. The thing I do not like to hear, and I will not let you say it in my office and get away with it. Oh, that didn't really count. It's not really worth much. I want to know about it because it might be worth more than you think it is once you actually start talking about it and thinking about what can be done with it. Select your fiduciaries. These are the people who are in charge of making sure that your wishes are carried out. That's your executor, your trustee, legal guardian for your minor children, legal guardian or conservator in case you become incapacitated, your agents, your healthcare agents, your power of attorney, all of those different individuals, making sure you're thinking through who in your life you will trust with your legal decisions, your financial decisions, your healthcare decisions, taking care of your children. They may or may not be the same people, but if you can take time out to think about who you would consider, it will make the process a lot easier for you. And finally, your team of advisors. Depending on what you own and how everything's set up, you might need an attorney, financial advisor, insurance agent, land use experts, business consultants, whoever it is that's already helping you with your business or who you would need to help you to plan out your current assets and everything. You want to assemble that team and you want to introduce them to each other so that they can work on a comprehensive plan that covers all the bases. When selecting an attorney, this is very important. You want to choose an estate planning attorney who can advise you on planning around retirement benefits, providing for family members with special needs, long-term care planning, managing family land, succession planning for a business that's associated with your land or just your own business, however you got it set up. Um, you don't have to, your estate planning attorney does not have to cover all these things if you don't have all these things. But if you have any of these things on the list, make sure that your attorney has that expertise or that they have an attorney that they can partner with to help them, excuse me, to help them create a plan that covers all the bases. Do not get your cousin who's a criminal law attorney or your sister who graduated from law school, but she never really got into practicing estate planning. Don't choose them to do your estate plan because there are attorneys who will say, I'll do your will for you, but they might miss some things if they're not doing estate planning on a regular basis. Choose someone you feel comfortable with. If they're talking in a way that is contrary to the way you see your estate going, your legacy, you need to find a different lawyer. There's probably going to be somebody who fits your personality, your goals, your needs. If you have special religious preferences that need to go into your estate plan, see if you can find a lawyer who specializes in that. Choose someone who understands and appreciates your personal, familial, and cultural values. Don't choose someone who sees the world completely different from you in terms of family and leaving a legacy and generational wealth, because it's not going to be a good match and you're not going to come away with a plan that you're proud of. I encourage you to be creative in your estate planning. I see this slide stuck in here. This is from when I'm talking to my landowners, but there's just different ways that you can handle the division of your estate that makes sense. Don't just say, well, I got 100 acres of land and I'm just going to give it to all my children. Or I have a house and I can't choose which of my children should get it, so I'm just going to let all five of them get it. Let's not set them up for failure. Let's not set them up for a fight. Let's make sure that your plan actually addresses unique situations, such as you don't want to create heirs property by leaving your one property to multiple children without a plan. If you have a plan, that's different. But if you don't have a plan, that can cause some issues. These are other pitfalls: tax issues, not planning for long-term care, not hiring the right professionals. These are things you can avoid because you already know that they are problems. And I'm telling you, Veronica is telling you, don't do these things because you won't be happy. And so that's all I have for y'all. But what I do want, if you are interested in working with my firm, if you are in Georgia, you are a Georgia resident and you're looking to do your estate planning, you can scan this QR code when in a few minutes when we do some Q&A. I'll put a link directly into the chat so that you'll have that available to you. And for folks on YouTube, I'll figure out how to get it to y'all too. I can't do Zoom and YouTube at the same time in terms of typing stuff, but we'll get y'all the link as well. Always you can leave a comment in YouTube if you want the link, and I'll drop it underneath your comment. But I if y'all want to work with me, I would be happy to. The way we get started is to schedule a getting started estate planning call. I have some time available tomorrow if you are like really ready to get started. This is initial call is a free call for me to talk with you about any loose end questions you have. We're not getting deep into, well, I got a sister who has disability and I'm trying to figure out, should I leave her stuff to this? Like, we're not getting into all the details of your plan, but we will be talking generally about how our firm approaches estate planning and what your concerns might be, what questions you have, and then we'll be talking with you about the pricing for getting started, depending on the type of plan that you have indicated. Um, what I will tell you is that the terms of our process, we start out with that initial call. Then we're going to have, once you decide that you want to move forward with us and doing estate planning, we're going to have, we're going to send an engagement letter and we'll have a way for you to make your payment. Then we'll have a design meeting, which is when we'll actually put the details of your plan in place and talk about who do you want to be over what, who do you want to receive what. We prepare your drafts and then we send them to you and we review them together. Then from that point, we will finalize your drafts and get you in to sign. If we need to schedule a remote signing, we can do that. And if you get a trust-based plan, we'll help you to transfer your assets into your trust. Because like I mentioned, there's a legal process you have to follow to get that done, and we can help you get that done. So, excuse me. This is our contact information. If you have any questions after this, I'm going to now go ahead and stop the live stream on YouTube. So YouTube folks, I'll see y'all later. Let me know if y'all have questions in the comments, and I'll be happy to respond to those after this Zoom session is over. But for those of you who are in the Zoom,